The content of this webinar is not intended to replace your firm policies and procedures, nor can it be deemed to be legal advice. You are advised to consult with your broker and your firm attorney to address the issues that are in your specific transaction. Aloha. Welcome to HAR's first webinar online, the ABCs of Act 66. We'll be talking today about an amendment to Act 137, which provides an exemption for licensed real estate brokers and salespersons. Act 66, the exemption. Effective May 20th, 2009, the 2008 Mortgage Rescue Fraud Prevention Act, what we commonly refer to as Act 137, was amended so licensed real estate brokers and salespersons are exempt from the definition of distressed property consultant. Specifically, 480-2 Hawaii Revised Statutes is amended by providing the following exemption. Distressed property consultant shall not include any of the following: a person currently licensed as an active real estate broker or real estate salesperson in Hawaii pursuant to HRS 467. When acting in the capacity of a real estate broker or salesperson in accordance with customary industry standards. So what this means is, if you are practicing real estate in Hawaii and you are adhering to your firm policies, procedures, and industry standards, you can avail yourself of an exemption which cuts you out or separates you from the definition of distressed property consultant. As you recall, that was the provision that gave us so much trouble with Act 137. To qualify for this exemption, the listing agent cannot acquire an ownership interest either directly or indirectly within 365 days after the listing agreement for the same distressed property has expired or is terminated. So what this means is you cannot buy or have someone buy for you an interest in any property that you've listed that is distressed. A word of caution. It is unclear at this time whether the restriction against a realtor acquiring an interest in a distressed property listing applies to all the listings held by a particular company. As you know, it is actually the broker that technically holds the listing, not the individual salesperson. At this time, the state of Hawaii has not clarified its position as to whether they will deem all listings restricted to any given salesperson in a given company. Aloha. Welcome to part 2 of HAR's first webinar online. Today we're talking about Act 66, which provides an exemption for realtors from the definition of distressed property consultant under Act 137. To this end, HAR has modified its forms to reflect the exemption provided by Act 66. So we have a new short sale addendum to the listing agreement, a new distressed property addendum to the listing agreement, as well as a new short sale addendum to the purchase contract and distressed property addendum to the purchase contract. Each of these forms has been modified to require the seller to inform his or her broker whenever his property becomes a distressed property under the definition provided in the Act. It also deletes previous restrictions against realtors from interacting or contacting a seller's lender. For example, I'm turning to the distressed property addendum to the listing agreement. It provides that the seller hereby agrees to notify the brokerage firm immediately if the property is, or at any time during the term of the exclusive right to sell listing agreement, becomes a distressed property, or the seller uses, hires, or retains a distressed property consultant. Should seller fail to so notify the brokerage firm, the seller shall indemnify and hold the brokerage firm harmless from any claims arising therefrom or related thereto. Remember, whenever you're thinking about whether Act 137 applies to your particular transaction, you need two things: a distressed property as defined by the Act, and a distressed property consultant. Without both of these elements, Act 137 simply doesn't apply, and you can proceed to closing as if it were a normal transaction.